In this episode, we will be discussing right to information, RTI, and the concepts related to it. Let's begin with a brief introduction. According to Thomas Jefferson, information is the currency of democracy and is critical to the emergence and development of a vibrant civil society. The Right to Information Act 2005 is a law enacted by the Parliament of India to provide for setting out the practical regime of right to information for citizens. Under this Act, an Indian citizen can access the information from the public authority. Article 19(1) of the Indian Constitution guarantees us the right to freedom of speech and expression, and as recognized by the Supreme Court, this also implies a full right to information. Significance: empower citizens to take charge by participating in decision making and by challenging corrupt and arbitrary actions at all levels. With access to government records, citizens can evaluate and determine whether the government they have elected is delivering the results that are expected. Access to information can empower the poor and the weaker sections of society to demand and get information about public policies and actions, thereby leading to their welfare. Shifting towards historical background of RTI. First right to information law was enacted by Sweden in 1766. The right to information gained power when the Universal Declaration of Human Rights was adopted in 1948. It provides everyone the right to seek and receive information and ideas through any media and regardless of frontiers. The International Covenant on Civil and Political Rights 1966 states that everyone shall have the right to freedom of expression, the freedom to seek and impart information and ideas of all kinds. The idea of RTI Act in India was floated by the former Prime Minister of India, Shri V.P. Singh, in 1990. The first grassroots campaign for the introduction of RTI was started by Mazdoor Kisan Shakti Sangathan in 1994. National Campaign for People's RTI, formed in 1996, formulated initial draft of RTI law for the government. Tamil Nadu became the first Indian state to pass RTI law in 1997. Freedom of Information Act 2002, passed by Parliament, could not be implemented. Bill for the present RTI Act 2005 was passed on the recommendations of National Advisory Council in May 2005, and RTI Act 2005 became effective from October 12, 2005. Now we will focus on objectives of the RTI Act. To empower the citizens, to promote transparency and accountability, to contain corruption, to enhance people's participation in democratic process, looking at the salient features of the Act. Section 2F. Information means any material, in any form, including records, documents, memos, emails, opinions, and advices, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, and models. Data material held in any electronic form and information relating to any private body which can be accessed by a public authority under any other law for the time being in force. Section 2J. Right to information means the right to information accessible under this Act which is held by or under the control of any public authority and includes the right to inspection of work, documents, records, taking notes, extracts or certified copies of documents or records, taking certified samples of material, obtaining information in the form of diskettes, floppies, tapes, video cassettes or in any other electronic mode, through printouts where such information is stored in a computer or in any other device. Section 4 of the RTI Act requires suo motu disclosure of information by each public authority. However, such disclosures have remained less than satisfactory. Section 8(1) mentions exemptions against furnishing information under RTI Act. Section 8(2) provides for disclosure of information exempted under Official Secrets Act 1923 if larger public interest is served. The Act also provides for appointment of information commissioners at central and state level. Public authorities have designated some of its officers as public information officers. They are responsible to give information to a person who seeks information under the RTI Act. Time period. In a normal course, information to an applicant is to be supplied within 30 days from the receipt of application by the public authority. If information sought concerns the life or liberty of a person, it shall be supplied within 48 hours. In case the application is sent through the Assistant Public Information Officer or it is sent to a wrong public authority, then 5 days shall be added to the period of 30 days or 48 hours as the case may be. What is public authority? Public authority means any authority or body or institution of self-governance established or constituted by or under the Constitution, by any other law made by Parliament, state legislature, by notification issued or order made by the appropriate government, and includes any body owned, controlled or substantially financed. Non-government organizations that are substantially financed directly or indirectly by funds provided by the appropriate government. Now, let's discuss the Right to Information Amendment Act 2019. It provided that the Chief Information Commissioner and an Information Commissioner of Centre as well as States shall hold office for such terms as prescribed by the central government. Before this amendment, the term was fixed for 5 years. It provided that the salary, allowances and other service conditions of the Chief Information Commissioner and an Information Commissioner of Centre as well as States shall be such as prescribed by the central government. Before this amendment, the salary, allowances and other service conditions of the Chief Information Commissioner were similar to those of the Chief Election Commissioner. Information Commissioners were similar to those of an Election Commissioner, State Election Commissioners in case of states. It removed the provisions regarding deductions in salary due to pension or any other retirement benefits received for previous government service of Chief Information Commissioner and Information Commissioner, State Chief Information Commissioner and a State Information Commissioner. Looking at issues in the amendment. The information related to decision making at the highest level has in most cases eventually been accessed because of the independence and high status of the Information Commission. These amendments will lead to the dismantling of transparency architecture as they empower the central government to unilaterally decide tenure, salary, allowances, and other terms of service of information commissioners, both at the centre and the states. The Commission, which is vested by law with status, independence, and authority, will now function as a department of the central government. These amendments fundamentally weaken an important part in the RTI architecture. The amendment violate the constitutional principles of federalism, undermine the independence of information commissions, dilute the widely used framework for transparency in India. It was because of these reasons this bill has been called an RTI elimination bill that removes the organization's independence. The RTI Amendment Act 2019 was criticized on grounds of diluting the law and giving more powers to the central government. Shifting focus towards the RTI versus right to privacy. Conceptually, RTI and the right to privacy are both complementary as well as in conflict to each other. While RTI increases access to information, the right to privacy protects it instead. At the same time, they both function as citizens' rights safeguarding liberty against states' overreach. When the question of harmonizing the contradicting rights arises, it should give justice to the larger public interest, advance the public morality. Now, let's discuss the RTI and political parties. Activists want political parties to be brought under RTI because to contain corruption, huge donations from corporates which lead to favoritism or crony capitalism, illegal foreign contribution. The leader of the opposition is statutorily mandated to be part of the select committees to choose chairperson for CIC, Lokpal, CBI director and CBC. Various members of the opposition are also part of various parliamentary committees. They enjoy multiple benefits like concessional office spaces, free airtime on DD and All India Radio from government. Stand of political parties. Political parties are not public authorities, hence cannot be brought under RTI Act. Disclosed information can be misused. Can disclose financial information under the IT Act. Let's discuss a few challenges related to RTI. Misuse of RTI Act. Due to non-applicability of locus standi rule to RTI case and non-requirement of giving reasons for seeking information, it has been observed that the RTI Act is misused by many petitioners. This leaves ample scope for non-serious information seekers to misuse it for their personal interest rather than public interest in disclosure. Also, this diverts the time of public servants and adversely affects their work. Low public awareness. Public awareness is very low in India regarding their rights as well as duties. Some reasons behind this are lack of education and awareness. It was further observed that awareness level is low among the rural areas and in disadvantaged communities such as women, SC, ST or OBC. Huge backlog and delay in disposal of cases. One of the reasons the RTI Act was considered to be revolutionary was that a response has to be provided in a fixed time. failing which the government official concerned would be penalized. However, this time-bound nature of the Act suffers due to multiple reasons. Due to insufficient number of information commissioners at the central level, there is a high backlog and delay in the hearing of the cases. Further, because of poor quality, incomplete and inaccurate information, the first appeal increases significantly under the RTI Act. Moreover, the Act doesn't provide any limit within which the second appeal to Chief Information Commission must be heard. Ineffective record management systems and procedures to collect information from field offices lead to delays in processing RTI applications. Issue of enforceability. The Act does not give adequate authority to the Information Commissions to enforce their decisions. Information Commissions can give directions to public authorities to take the steps necessary to comply with the Act. They are not empowered to take any action if such directions are ignored. Secrecy. The free flow of information in India remains severely restricted by the legislative framework, including several pieces of restrictive legislation such as the Official Secrets Act 1923. Other issues. Information commissioners do not have adequate authorities to enforce the RTI Act. In case of award of compensation to activists by public authority as ordered by Commission, compliance cannot be secured. Poor record-keeping practices. Lack of adequate infrastructure and staff for running information commissions. Dilution of supplementary laws like the Whistleblowers Protection Act adds to the administrative burden of the bureaucracy. Moving on to the way forward. Open data policy. Government institutions should put all disclosable information on their respective websites. By this, the petitioners may immediately access whatever information they need. This will also reduce the burden of the department to provide information which takes much of its valuable time. Compiling of similar RTI applications. Many RTI applicants file multiple RTI applications on the same subject, seek the same information, which increases the burden of the information department of various public institutions. Also, a system needs to be put in to weed out such duplicate cases. Preventing misuse of RTI. RTI misuse can be prevented by introducing the reason-knowing provision for filing the petition. Also, there should be a provision of penalty for wasting the valuable time of the Information Commissioner for demanding unnecessary information or which is not in public interest. Balancing with privacy right. Another right of a citizen protected under the Constitution is the right to privacy. This right is enshrined within the spirit of Article 21 of the Constitution. Thus, the right to information has to be balanced with the right to privacy within the framework of law. Increasing public awareness. This can be done by the launch of awareness campaigns through radio, television, and print media, various regional languages in rural areas. A chapter on RTI Act 2005 should be added in school and college curriculum. Central State Information Commission should be provided with sufficient funds for creating awareness about RTI Act 2005. To watch our videos in Hindi, subscribe to our Hindi YouTube channel Drishti IAS.